Assalamualaikum warahmatullahi wabarakatuh. Before I start my presentation, let me introduce myself first. My name is Muhammad Arazim bin Faizal. I am from Ahaz Kirkis. I am from Bahim and I am majoring in Bahim and my metric number is 2315697. So, inshallah, I will tell about history of Islamic law in Malaysia. Firstly, before the existing federal constitution in Malaysia, our country was implementation and using the Islamic rule and law in our ruling system. For instance, the law that we have been using is uh, Undang-Undang Melaka, which is Malacca law, Undang-Undang Pahang law, Undang-Undang Kedah law. Based on my reading, the earliest law in Malaysia started when Malacca was a Malay kingdom in early 15th century. A compilation of law was made on the order of the ruler, and the Undang-Undang Malacca law, show the influence of Islam in Malaysia customary law. Also, people on that day are most Muslim, and actually, if a citizen is Muslim, is a quiet, not hard, it's quite easy to apply the Islamic law in the country. Furthermore, the one that the king of Malacca have fully power in manage the country, and no power is above him. So we know that the Sultan Malacca has a fully power and no one can fight him. So the king of Malacca can apply any law that he want, and normally the king will ask the minister advice in Malacca before enforce the law in his country. It must be questionable to all of us why Islamic law was applied in Malacca that time. Actually, based on history, it is because of influence of Arabic culture and the spirit of preaching Islam in the Nusantara. As we know, in 15th century, Malacca was one of the famous port or harbor in the world because the ships captain wanted to avoid from monsoon wind. Basically, Malacca port was being famous day by day that time. On that time, merchants from Arab come and spread the Islamic knowledge and virtue to Malacca. Moreover, they teach the Islamic knowledge and spread of preaching Islam to King of Malacca too. Therefore, we can see a lot of evidence that show Islamic law was implemented in our country before. The earliest record about Islamic law that have been found in our country is an inscription on a stone was called a Batu Bersurat Terengganu, which it was written since 1303 Masih. For example, the Islamic law that have been wrote in on the stone is about adultery, which is zina. It was said in bahasa Melayu, orang berbuat bala cara laki-laki, perempuan titah dawata maharaja jika merdehika bujang palu 100 rotan. Jika merdehika beristeri atau perempuan bersuami ditanam hinggakan pinggang dihampalang dengan batu matikan. If we translated the inscription that have been written in English, it will be understand. It will ask those who commit unlawful intercourse between male and female, the order by the God are, if they are free person, which is they are not a slave, and unmarried, they will be flogged 100 lashes in. And if the free man has a wife or the free woman has a husband, they will be buried till waist and will be stoned until they die. Hi and Assalamualaikum, and we met again. So let's move on into another part of history, which is history making of Federal Constitution in Malaysia. As we know, the Federal Constitution of Malaysia was established when our country achieved our independence, which is in 31 August 1957. Actually, there have been a lot of things that our country have been through to achieve our independence. Many people in many background were doing the best to make it happen, to make sure that our country achieve the independence. The most important role that making the Federal Constitution of Malaysia is the United Malaysia National Organization, or famous with the term UMNO. The United Malay's National Organization was formed in 11 May 1947 in Johor, and the United Malay's National Organization (UMNO) was the first Malay political party as a result of the first Malay Congress and with the support of Sultan Johor, Sir Edward Gann, and Malcolm MacDonald, that the British government had agreed to consider the recommendation of Malay rulers and for UMNO to draft a new constitution for Malaysia. Eventually, 11 committee members led by Dato' On Jaafar were entrusted to draft a new constitution to replace the Malaya Union Constitution on 25 July 1946. I'm sorry. On 1 February 1948, the Federation of Malaysia, Malaya was officially formed, which is it was the same date when the Federation of Malaya Order in Council come into force in our country. If you can see, the making of federal constitution of Malaysia was started of abolish fully Sharia jurisdiction in our country. Is it real? Actually, yes. The way stream of modernism is making us slowly changes from customary law, which is before the uh, federal constitution was applied in our country, and it lead us to the more systematic law. The making of federal constitution of Malaysia is not mean that Sharia law in our country is 100% abolished, but it actually mean that a few part of implementation of Sharia law in our country was changed.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Afiq bin Irfan. My metric number is 2318655. Based on Article 3, Bracket 1, Islam is the religion of the Federation, but other religion may be practiced in peace and harmony in any part of the Federation. This matter was included in Federal Constitution in 1957 when it framed in the Independence Constitution. In Malaysia, there are a majority of people that follow Islamic religion, which present 3/5 of population. Islam is one important factor distinguishing a Muslim from a non-Muslim, and by law, all Malay are Muslim. This proves that majority of Malaysians are Muslim and they not put barrier to who want to follow the other religion. Besides that, every state that have sultan, they represent sultan as their chief of religion in their state. So ruling must be referred to sultan before approve something about religion. For example, in Kedah, Kelantan and Terengganu. This contradict with constitution of state of Melaka, Pulau Pinang, Sabah and Sarawak who do not have sultan. Yang di-Pertuan Agong will represent this state, which being the chief of religion, and YDPA also being head of religion in territories. They are also make great Sharia court to over Muslim in respect of the Islamic laws. Other than that, Malaysia provide freedom of religion to all Malaysian people, which enriched under Article 11 of the Federal Constitution, and states that every people have right to profess and practice his religion subject to clause bracket 4 to propagate it. It is well known that the Federal Constitution protect the freedom to believe or practice any religion, and that no limitation or obstacle to any religion in Malaysia. To conclude that Malaysia is a country that declare that Islam is an official religion and does not prevent its people from following the other religion. Every people of Malaysia have freedom to speak and right to believe or practice what they want. Next, the first case that we want to discuss today is case Cik Omar bin Cik Sofi as public prosecutor, Saleh bin Abbas as the judges, delivering the ground of decision of the court, which is the additional ground of appeal in criminal appeal notes 28 and 29 of 1986 to show that a mandatory death sentence for the drug trafficking offence and the offence under the firearm increased penalty. Act 1971 Act 37 is again the injunction of Islam and therefore void. It's argued that since Islam is the religion of federation on Article 3 in bracket 1, and since the constitution is the supreme law of the federation, Article 4 in bracket 1, the imposition of the death penalty on this offence not being hudud or qisas according to Islamic law is contrary to Islamic injunction and is therefore unconstitutional. But public prosecutor against him with Cik Omar Cik So with our country is a secular country. It means Islam not practiced in world religion. It means Article 3 Islam is only practiced in ritual and ceremony. There is no doubt Islam is a complete way of life in all matter, including its jurisprudence and moral standard. Then the submission has a great implication in that very law has to be tested according to the yardstick. Islam is also organizing life with all the law and standards. Morality is based on divine guidance. The judges in this case say this dichotomy is how drafter of constitution understood the word Islam in context Article 3. If the law is actually based on Islam, then of course many things in constitution will be void. Despite of that, they adds Article 162 on the other hand purposely preserve the continuity of secular law prior to the constitution unless such law is contrary to the letter. This case make the prosecutor advantage and Cik Omar Cik So forced to serve the death penalty. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Before I start my presentation, I would like to introduce myself. My name is Mirza Shami bin Zahiri and my matric card is 2318013. I'm from Department Ahas KIPHS and I'm majoring in Fiqh and Usul Fiqh. Inshallah, I will tell you about two cases this night, which is the first case is about Mio Atikur Rahman and the second case is about Lina Joy. We go to the first case, Mio Atikur Rahman bin Ishaq and others versus Fatimah binti Sihi and others, 2005 MLJ 375. The plaintiff claimed to have been dismissed from a school for wearing turbans in school beside wearing the school uniform. The plaintiff seek for a court order to declare that the expulsion from the school void, null and no effect, and they should be accepted back to the study in the school. The defendants in their defense contended that the plaintiff in wearing turbans in school had breached Article 3, Clause 5, Clause V of the circular letter number 9 1975, Ministry of Education. The circular letter inter alia provided the headmaster could also consider other matters which are not in the list according to the circumstance and their respective school. The central matter before this court is whether the right to wear a turban is a fundamental component of Islamic faith. I will tell you about the reason that the respondent gave to the judge, how along the appeal. First, they said that the fundamental right of freedom of religion guaranteed by R11 Clause 1 of the Federal Constitution had been infringed because they had been prevented from entering school wearing a turban, which is a part of their religious right. The appellants refusing the respondent permission to attend school wearing a turban. The appellants had violated their profess and practice the religion of Islam. As we know, we have our rights, we have our freedom to practice our religion by wearing turbans or whatnot. And based on the Article 11 Clause 1, does not allow any contrary to any general law that relate to public order, public health or morality. As we know, wearing a turban doesn't violate anyone and doesn't give bad effect to another citizens. Not like Hajah Halimatul Sa'diyah cases that he wearing a purdah and it might be violate other citizen, and it will make other citizen feel scared, and they can recognize who is is it she or him, and I think that Hajah Halimatul Sa'diyah is violate the Article 11.5 because of if she wearing the furdah is contrary the general law that relate to public order, public health or morality, and there is not reason to prohibit the wearing of turbans at the school. After hear all the reason above, the judge decide it was invalid, null and void their school expulsion is not effective. The judge ordered that they be readmit to the school and order the defendant to pay damage and costs. Alright, we go to the another case. Lina Joy versus Majlis Agama Islam Wilayah NU 2004 2 MLJ 119. The appellant was born on 8 January 1964 of Malay parents practicing the religion of Islam. She was born as a Muslim and her name originally was Azina binti Jalani. She claimed that she had never believed in Islam, that since 1919 she had believed fully Christianity. She was baptized and married a Catholic man. According to the Law Reform Marriage and Divorce Act 1976, Lina could not register with the Registration of Marriage for non-Muslim because her identity card shows she is a Muslim. Lina Joy made a statement in the prayers 1, 2 and 3. She has a freedom to profess a religion of her choice under Article 11 Clause 1 of the Federal Constitution. As we know, the Article 11 Clause 1 is tell about we have our freedom to profess of a religion of a choice of our religious, but not about we have our freedom to choose a religion. We have our right to practice our religious, but not we have a freedom to choose another religion, like we can choose Christian, we can go to Buddha, or we can go to the we can go to the another religion. This Article 11 Clause 1 tell about we have our freedom to practice all the practice in our religious. Alright. On 21 February 1997, the plaintiff applied to the National Registration Department (NRD) to change her name from Azlina binti Jalani to Lina Lelani, that had judged by Faizah Tambi Cik J, but her application to NRD to change her name was rejected on 15 March 1999. However, the plaintiff applied again to NRD to change her name from Azlina binti Jalani to Lina Joy. The plaintiff made another application to NRD to remove the word Islam from the plaintiff's new identity card, but still been rejected by NRD. As a consequence, her marriage is considered invalid by the state. she cannot have a family because any children she had will consider as a Muslim by the state and consequently by taken away from her Christian mother. So Lina Joy can make a family and she can she can have a child, and the child will automatically be taken away from the mother because her mother is Christian. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Syamil bin Ahmad. My metric number is 2311441. And now I will present about the Ang Wan Chan case versus Federal Territory Islamic Religious Council and NR. The issue concerns Islamic law and the assessment of whether or not the deed was a Muslim at the time of his deed. The plaintiff is the widow of Lee Siu Ki. In this lawsuit, the plaintiff has applied for a declaration that her ex-husband, the deceased, was a lifelong Buddhist at the time of his deed on May 2, 1991. According to the Federal Territorial Islamic Religious Council, the deceased was a Muslim at the time of his deed. A copy of the deceased legally verified conversion application from December 24, 1973 has been submitted. The ceremony of conversion to Islam was reported to have been conducted by Haji Adam Kesir Chow. However, there is no indication of the date or location of the ceremony, and there is no proof that Haji Adam Kesir Chow is an official at start in the application form. The following are the main questions that emerged in this case. If the deceased, a Buddhist, was fully converted to Islam in 1973, whether the deceased had embraced Islam at the time of his death, and he has perfectly converted to Islam, whether he abandoned Islam and become an apostate before he dies. The challenge for the Majlis to successfully oppose this application, the Majlis must produce evidence to show that the conversion of the deceased to Islam has been done in accordance with the requirement of Islamic law. The Majlis must prove the fact that the process or rite of conversion had been properly performed. The second case is Lim Chan Seng versus Director of the Penang Department of Islamic Religion and another. The plaintiff applied for a declaration that he had lawfully renounced the Islamic faith by his deed poll date 12 July 1995 respectively. The plaintiff averred that he had embraced Islam on 22 February 1994 and changed his name to Muhammad Alif Lim bin Abdullah, and that on 12 July 1995 by a deed poll he had renounced the Islamic faith and expressed his desire to use the name Lim Chan Seng. The defendant, the Pengarah Jabatan Agama Islam Pulau Pinang, sought to challenge the jurisdiction of the High Court to entertain the plaintiff application. Clearly, by the enactment, the Sharia Court had not been a court with jurisdiction over the matter raised, and that being the case, it follows that there is no impediment for the civil court to hear and dispose of the matter. Moreover, one way to overcome the conflict or challenge of the jurisdiction between the two courts is by giving the civil court power to hear and decide all the issues in the case, including issues pertaining to Sharia law. However, during the trial, the civil court judge shall be assisted by Sharia court judge, and the latter decision on Sharia law shall be binding against the civil court. Another latter decision on Sharia law shall be binding against the civil court. Another drastic solution of challenge would be by combining both the courts, which means that Sharia judge should also be appointed to the civil courts. Consequently, issue concerning the two jurisdictions shall be presided and heard by both the judge. The civil judge will decide upon the civil matter, while the Sharia judge on his part will decide on the Sharia matter. And the last case is Muhammad Hakim Lee versus Islamic Religious Council of the Federal Territory Kuala Lumpur. Plaintiff was born a Buddhist. He embraced the religion of Islam on 30 March 1978 and used the name of Muhammad Hakim Lee. But by the deed poll and the statutory declaration, he has renounced the religion of Islam and showed an intention to use the name of Lee Long Kim in place of Muhammad Hakim Lee. It is only the Sharia court which could validly make a declaration whether his renunciation of the Islamic religion through the deed poll of 12 October 1995 is in accordance with law and valid, and also to declare whether or not he is required to obtain the consent of the defendant to renounce Islam. The challenge by a correct approach is to first see whether the Sharia court has jurisdiction and not whether the state legislature has power to enact to the law conferring.
Assalamualaikum warahmatullahi wabarakatuh. I'm Muhammad Farhan Malakman. So I would like to continue the presentation. So I would like to share to all of you one of the challenge in Sharia court jurisdiction, which is the intervention of civil court jurisdiction over the Sharia court. So as you all know, in our legal system in Malaysia, it have dualistic system, dualistic structure, which is consisting of civil law and also Sharia law. So, as we all know, we have amendment which is the Article 1211A, which is Federal Constitution has mentioned that the High Court and the courts under it do not have any jurisdiction over any matter within the jurisdiction of the Sharia court. So all matters about marriage and also the property about Muslim. So there is any high court, it can uh, it cannot be stipulated. Okay, so I would like to share to all of you two cases according to this case, which is according to this topic. The first one, the claim of marital property after death. Also it have some khilaf and also some problems, which is the intervention civil court towards the problem. And the second one, which is child custody and determining the child religions for a couple where one of them has converted to Islam. So how to decide uh, who, who can be Muslim or not. So for the case number one, Jumaatun fight with the Raja Hizaruddin. So basically this case is actually about two wife married one man, and the man died. So the disease have a lot of money, which is almost 11 million ringgit. So these two wife appeal to get their rights, and one of them uh, except for one of them. So one the second wife didn't get their rights, which is she has no right to get that money. So she appealed for her right. So it has two initial questions about this problem, this case. The first one, whether both people appealing have the right to bring this case because they are not in charge of the deceased person's staff and can't speak for all other family members. So, and the second question come up from this case is whether the Sharia court has power, has jurisdiction to make the decision like the appellant are asking for. So, what is the result? The result is the claim was rejected. So the two people which is the appellants, which is the second wife and also his son, her son, um, unhappy with the decision made by the Sharia court. So and also their appeal was also rejected. Why? Because these things all under the federal law, and there's a specific law which is the probate and administration under the Act 1959. So they doesn't have any rights to the property until all matters finish. All matters according to the disease money lah. Okay, moving on to the next case, which is case number two, Indira Gandhi uh, versus Pengarah Jabatan Islam Perak. So, um, this case basically uh, the husband obtained custody orders for all three children from the Sharia court. So, the husband convert to Islam. When the husband convert to Islam, so he won all his three sons also convert to Islam, but um, his wife object that decision. So his wife want to appeal for get her rights, which is the then when she appeal after day by day, the High Court approved the wife request and said that the certificates from the registrar should be cancelled. So in that case, the wife win, which is she got the appealing request. So then in these appeals, the court's appeals decision, which is it means that uh, the wife want to fight uh, for the high court make decision that tell us that Sharia court has no power to decide a Muslim status. So what happened? What is the result? The result is finally the High Court um accepted the wife application for judicial review, but to cancel certificates of conversion to the Islamic religion. So in these appeals, the decision of the court appeal that the authority to decide the status of a Muslim within the exclusive jurisdiction of Sharia court, and the other high court declaring the convention null and void is violation of section 53. So the result is no matter how people do, the decision is only the decision of the status of Muslim is only made by the Sharia court. So in this case, the Sharia court win because of the uh, enactment of section 53 of the Perak enactment, which is incorrect. So I think that's all for me. Inshallah, Assalamualaikum.
Assalamualaikum warahmatullahi wabarakatuh, and we meet again for the last chapter for this presentation. So, best, what can I conclude from the this presentation is we can identify and we can understand the challenge between position of Islamic law under federal constitution and its challenge as the official religion of the country. From all the cases that we have discussed, we can see that they have some similar, which is people are using civil court to against Sharia court. We also view the history of Islamic law and civil law in Malaysia. Moreover, we're also talking about Article 3.1. It's about position Islam as official religion in the Federal Constitution of Malaysia, but it does not mean that Islam include Islam ideas just because Islam the predominant religion in Malaysia. It also means that the other religions still can be practiced in Malaysia. Also, we interpreted about the challenge between civil law and Sharia law in this presentation. Therefore, we also related the article 1 to 1, 1A, sub 1A. In this assignment, article 1, this article is about the one court cannot interfere the other court. For instance, Sharia court cannot interfere with civil court. So, before I end this presentation, I'm so very grateful for you to hear from the beginning until the end. So, if have any mistaken or any misinformation or misunderstanding in our presentation, we are very sorry, and we hope that we can make it better soon. So, uh, kullu haza faqat minna, kullu khairun minallah wa kullu naqsin minna. Assalamualaikum warahmatullahi wabarakatuh.